matter, my lord. I got admission in the MBBS course in the first round.
Before vacation, move the vacation.
My admission, after admission, my lord, they have cancelled the seat allotment. Taking the plea that I had a OBC certificate, which had already been cancelled by the virtue of court's order. I applied for EWS that I got. In terms of EWS, my lord, I have been admitted. Now, after admission, they have, my lord, cancelled the allotment. But they may fill up this by Monday, my lord, they will fill up the vacancy. Kindly take the matter.
Sorry, I cannot.
It's about third round.
File it. If it comes.
My lord.
No leave will be granted.
My lord.
As led by Learned Advocate General, he is.
May I mention, Milord, that matter, Milord, which I mentioned day before yesterday?
What I was given the understanding that will you proceed during this vacation period?
Well, because this is 1 month, my lord, because there is a statutory timeline bound.
You have to wait. Please, I cannot take up this matter. Fate is rejection. Mr. Dotto knows this very well, but I cannot record the formal rejection.
Well, lord.
Wait for this month.
Well, yes, well, let him hold his breath for a month.
No order, my lord. I will direct my...
No, direct, but no coercive step.
Yes, my lord.
They will participate. They will do whatever,
Yes,
but no coercive step. I am not saying that you will adjourn, but wait for the...
Milord, kindly do not say that, Milord. Your Lordship hears this matter, Milord, after the vacation, Milord, whatever is the...
I am just saying that...
We have to accept.
I understand.
No coercive step. Wait for the rejection after vacation.
Yes, my lord.
Let me have the pleasure of rejecting.
But Milord, he should not fix any date, Milord, in the meantime. His client, I mean.
If date is fixed, I will give instruction. It will adjourn, my lord.
Even after vacation.
But it has been filed. It is appearing in the...
Well, at least, my lord.
Not appearing.
Yes, Mr. Dotto, where is that? Your outline of argument?
Yes, here.
Yes, it's there, Milord. Yesterday, Milord, we could not file it, Milord, for
soft copy.
The natural calamity.
You provide me a soft copy.
This has been handed over by Mr. Shishanno Bandyopadhyay to me.
Milord, I'll arrange for a soft copy, Milord. I'll arrange for a soft copy.
Of the state.
Yes.
Give me a soft copy.
We will
give me a pen drive. I will take it in my laptop. Then I will return your pen drive. It is your submission on the point.
Yes. My submission.
এটা দেখি একটু দেখি
pen drive এ soft copy চাই
নিচে যেতে দেখছেন দর্শক কি মেনশন করছে না শুধু জাজমেন্ট ওটা জাজমেন্টের কম্পাইলেশন তো জাজমেন্ট অতটা ঠিক আছে but written notes is not much the compilation we have given one but we also give the soft copy of it.
Including the soft copy. The judgment
or both.
Thank you. Great. Call the list.
My lord, may I mention this urgent matter, my lord, WPA 2788 of 2024, my lord. These are the applicants before your lordship are medical students of Kollani Medical Hospital, my lord. They have been debarred from the hostel since September by dint of an interim order. And which expired
out of hostel for this puja after puja.
My lord, the urgency is that the exams are commencing from the 13th of October, my lord. The theory exams are commencing from. My lord, kindly hears me.
Sorry.
My lord, they are ousted from the.
I have to read the states. This volume of.
My lord, the funny part is that the college authorities are telling them that to withdraw the application only then they will be allowed in the hostel. My lord, kindly takes it up before the vacation. It is extremely urgent, my lord.
But they will put this matter in the round, my lord. This is supposed to be filled up. This vacant should be filled up, and I would be nowhere. That's the reason, my lord. I'm giving
so confident that you will be getting that much chance.
EWS that confirmed.
You have obtained fraudulent OBC.
No. OBC, it's not mine. 2009 OBC was there. By being division bench order, all those OBC certificate gone.
One thing. Who is for the? It is the counseling, Mr. Nag.
Yes.
Bring Mr. Nag. Let me understand what is the depth of the matter. Then I will. Bring Mr. Nag at any point of time.
Great, Lord.
Lord, I'm being told that if your lordships please to keep this matter after vacation, the Ramakrishna Vivekananda mission, so that we can communicate the observation
If
of
a date is
lordship
picked
to
up.
the estate officer, my lord.
He is representing the state officer.
No, no.
It is
I'm saying,
understood.
yeah, it is understood, but
They
the
will not take
matter,
any coercive steps, but
coercive step, it is not a question of coercive. The date may be fixed in this matter. Any day after vacation, as per your. So I will instruct them.
Because it is what is the difficulty of this court. This court will not be available because immediately after reopening, I will be in circuit. After circuit, please take the pain of mentioning. I will
Well,
bring it.
very
in
well.
that.
Very
Call the list.
Number 1.
Who is for the review applicant?
Judgment.
Oh, why? No, this. Oh, for judgment one. Sorry, I missed it.
I apologize.
I bring the other side. Who has at the applicant? Please be here.
The only time when we feel we have nothing to do except
You may feel, but I have nothing. Even in the morning. That is why I'm late. পেন দাও না কালো পেন কোথায় গেল আমার একটাও নেই other than the government sponsored in-service doctors after completing postgraduate and postdoctoral courses from the state medical teaching institutions. As per the indemnity bond executed at the time of admission, are obliged to serve the state by working in different government hospitals as senior resident, SR in short, for a certain period of time. The Department of Health and Family Welfare, Government of West Bengal, the department in short, in order to get such service of the said class of doctors, wide order bearing number such and such dated February 16, 2023, has prescribed a standard operating procedure, the SOP in short. The issue falls for consideration in the present matter, present writ petition is whether the department is bound to follow the procedures prescribed under the said SOP to deploy and or engage the said SRs during the said bond period. The undisputed facts necessary to deal with the aforesaid issue are thus. The petitioner in the year 2025 has completed the MD course in the discipline of anesthesiology from Arjikar Medical College and Hospital, a government medical college. The petitioner, in terms of the indemnity bond executed by him, is obliged to serve the state for a period of 3 years. The department, in order to get such service from the said class of doctors, intended to engage them at senior resident at different types of government hospitals, and as the first step to achieve the said goal, had published a notice bearing number such and such dated March 4, 2025, thereby instructing the said doctors who have passed MD MS course in the year 2025 to complete the online registration between the period from March 6, 25 to March 10, 25 for the purpose of conducting counseling to engage them. The petitioner had completed the said registration within the stipulated time. The department thereafter, by a notice bearing number such and such dated March 6, 2025, had announced the schedule of the said SR counseling, and prior to the commencement of such counseling, the department, by a notification bearing number such and such dated March 21, 2025, had published a list of SR vacancies to be considered for the engagement of the said class of doctors. In the said list, 4 vacancies in the discipline of anesthesiology at the Arjikar Medical College were declared. The petitioner had participated in the said counseling on March 25, 2025, that is, the scheduled date of counseling in respect of his discipline. The petitioner, as per his merit position, had opted the second seat Out of the said 4 declared vacancies at the Arjigor Medical College and Hospital in his discipline. The petitioner had also submitted a formal declaration, thereby confirming the choice exercised at the time of counseling. The department thereafter, by the impugned notification dated such and such, May 27, 2025, has declared deployment of 871 non-sponsored postgraduate doctors mentioned in column B of the list annexed with the said notification to be engaged as SRs in the department mentioned in the column D, in the institution mentioned in the column E of the said list with immediate effect until further orders. The petitioner is alleging that the list annexed with the aforementioned notification, his place of posting as SR has been altered to Raiganj Medical College and Hospital, Uttar Dinajpur, by changing the choice exercised by him at the time of counseling arbitrarily. The petitioner is challenging the said notification and the list annexed thereto as so far as those documents relate to his place of posting. Then argument of Mr. Dhor, learned senior advocate for the petitioner, recorded as follows. The department by the SOP has prescribed a standardized protocol to deal with different issues of non-sponsored candidates to be engaged as SRs at different types of government hospitals, thereby enabling them to serve the state smoothly and without any dispute. As such, the state is bound by the provisions formulated in the said SOP. The decision of the Supreme Court of United States in the case of William Vincent Vetterelli, reported in 1959, SCC Online US SC 87, is relied on to contend that an executive authority must be rigorously held to be standards by which it professes its action to be just. The language of the said SOP is clear enough to indicate that it contains a complete mechanism for deployment of the SRs after completion of degree diploma, as the case may be. Paragraph 7A of the same SOP prescribes the department shall arrange for engagement of such candidate as SR for initial period of 1 year through counseling based on merit, prepared on the basis of collected stated matriculars. The state has no scope to deviate from the said prescription. The SOP prescribes a procedure aimed to eliminate arbitrariness. The state has clearly accepted the binding nature of the SOP inasmuch as it has followed the said procedure in deploying 869 out of the total 871 candidates, but strangely has deviated from it while deploying and or engaging only 2 candidates. One of them is petitioner. And in this case, state has adopted pick and choose method without assigning any reason. Such action of the state by reason of arbitrariness cannot be sustained, and same violates the Article 14 of the Constitution. The decision of the Honorable Supreme Court in the case of Sukhdev Singh and others versus Bhagat Ram and others, reported in 1975, 1 Supreme Court cases 4-1. In the case of Dr. Amarjit Singh Alwalia versus State of Punjab and others, reported in 1975, 3 Supreme Court cases 503. In the case of Ramanna Dayaram Sethi versus International Airport Authority of India and others, reported in 1979, 3 Supreme Court cases 489 are relied on to contend that the state action must not be arbitrary but must be based on some rationale which non-discriminatory. The decisions of the Honorable Supreme Court in the case of B.S. Minhas versus Indian Statistical Institute and others, reported in 1983, 4 Supreme Court cases 582. In the case of Home Secretary Union Territory of Chandigarh and other versus Darshit Singh, Griwal and others reported in 1993 4 Supreme Court cases 25, and also the decision of the Honorable Division Bench of the Allahabad High Court in the case of Ponam Singh and others versus State of UP and others reported in 2018 SCC online Allahabad 5677 are relied on to contend that once a policy has been adopted by the government, the administration is bound to follow it. The department, in its notification dated March 6, 2025, had made it clear that the choice once exercised by the candidate during the counseling will be final, cannot be changed under any circumstances. This said condition not only binds the candidate but also the department. Reliance is placed on the decision of the Honorable Supreme Court in the case of State of UP and another versus Bhavna Theory and others reported in 2025 SCC online SC 1367 to contend that the counseling is a process to ensure the principles of merit, fairness, transparency. Reliance is also placed on the decision of the Honorable Supreme Court in the case of Asha versus PT B.D. Sarma, Pandit B.D. Sarma University of Health Sciences and others, reported in 2012 Supreme Court cases 389 to contend that relaxation of the rule of merit in counseling is not permissible. The merit rank of the petitioner in the discipline of anesthesiology is 24 and his university rank is 25. The petitioner during counseling had opted the second vacancy out of please note of please had opted for second vacancy out of 4 vacancies at the RG Kar Medical College in the said discipline. But the department, for the reasons best known to it, has engaged lesser meritorious candidates, which Dr. Antara Danki having merit rank 26 and university rank 27, and Dr. Tripanna Chattopadhyay having merit rank 34 and university rank 32 in the 2 vacant seats in the said discipline of the said hospital. Nonetheless, 1 vacancy is yet to be filled up. The petitioner and 2 other doctors were prominent faces of RG Kar Medical College movement. They had faced police harassment for their such involvement, and to give them further lesson, the department, in arbitrary contravention of the procedure prescribed under SOP, has targeted them out of total 871 doctors of the list annexed with the impugned notification and have placed them in the hospitals far away from the hospital opted by them at the time of counseling as punishment posting. Now Mr. Dotto's argument has been recorded. The allegation of the petitioner must be scrutinized through 2 distinct aspects, that is counseling and posting. Counseling has to be based on merit, but the posting and or deployment is irrespective of the outcome of counseling. The petitioner has placed heavy reliance on the SOP, particularly paragraph 7A thereof, but it does not support the contention of the petitioner that the choice exercised during the counseling would directly reflect in posting. Such an inference would amount to putting words in the SOP. It is the prerogative of the state to deploy the petitioner wherever there is requirement. 2 out of 4 vacancies in the post of SR in the Department of Anesthesiology at Raiganj Medical College and Hospital, Uttar Dinajpur, are still lying vacant due to non-joining of the petitioner. Whereas RG Kar Medical College and Hospital, only 1 out of 4 in the RG Kar, only 1 out of 4 posts of SR in the relevant discipline is lying vacant. Therefore, in the interest of public service and considering the fact that Raiganj Medical College and Hospital is the only government medical hospital in the said district, the department had exercised administrative discretion in posting the petitioner to the said hospital to meet the requirement. Such administrative decision is within the authority of the department and also stands the test of reasonableness. The SOP is an administrative instruction which cannot be elevated to the status of statutory guideline or something flowing from the Constitution. As such, breach thereof does not confer any enforceable right on a member of the public to invoke the writ jurisdiction of the court under Article 226 of the Constitution. In support of his such contention, reliance is placed on the decision of the Honorable Supreme Court in the case of Union of India and others versus S.L. Abbas, reported in 1993 4 Supreme Court cases 357. In the case of R. Sai Bharti versus Jayalalitha and others, reported in 2004 2 Supreme Court cases, page 9. In the case of State of UP and others versus Govardhan Lal, reported in 2004, 11 SCC 402, and in the case of Chief Commercial Manager, South Central Railway, Secunderabad and others versus G. Ratnam and others, reported in 2007, 8 SCC 212. No consequence is contemplated for no non-compliance of the procedure prescribed in the SOP. As such, irrespective of the use of the word shall, it is directory in nature. To buttress such contention, reliance is placed on the division-based decision of the court in the case of Upanando Chatterjee versus State of West Bengal, reported in 2007 4 CHN 605. The notice dated 6 March 2025 notifies only the dates of counseling. It has no nexus with the post-counseling deployment. Effect of it starts and ends with the counseling. The choice exercised by the petitioner at the time of counseling cannot override the discretion exercised by the state in deploying the petitioner to meet the administrative exigencies and public interest. No cogent case has been made out as to why individual preference of the petitioner for a particular college and his inter-se merit ranking should carry greater sanctity than the administrative discretion of the state. Mere dissatisfaction with the place of posting by itself cannot be equated with the prejudice, legal prejudice. The phrase, if offered to me, appearing in the self-declaration of the petitioner, clearly indicates that the contemporaneous understanding between the parties has always been that there is no guarantee of an offer of deployment as per the choice exercised by the petitioner during counseling. Such choice is merely an option and does not become binding unless it is offered. The allegation and or contention of the state made in its affidavit in opposition are deemed to have been admitted as no reply to the said affidavit has been filed by the petitioner. On the point of doctrine of non-traverse, reliance is placed on the decision of the Honorable Supreme Court in the case of Lohia Properties Private Limited, Tinsukia versus Atmaram Kumar, reported in 1993, 4 Supreme Court cases, page 6. The petitioner, for the absence of specific allegation in the pleadings, not only has failed to make out a case of mala fide, but also is not entitled to set up such a case without impleading person against whom the allegation of mala fide has been sought to be leveled. On this point, reliance is placed on the decision of the Honorable Court in the case of Ratnagiri Gas and Power Private Limited versus RDS Projects Private Limited, reported in 2013 one Supreme Court cases 5-4. The case of Vincent Vittorelli, William Vincent Vittorelli Supra, need not be referred to even. No doubt, it is the obligation of the state to follow the principle laid down in the said decision, but the SOP does not confer any enforceable right upon the petitioner, and when there is no right, there is no question of discrimination or violation of Article 14 arises. Besides, in the said case, the legality of discharge of an employee in public employment was under consideration. In the first round of present proceeding, it has already been decided that the petitioner is not under public employment. Therefore, the principle laid down in the aforesaid judgment has no manner of application in the present case. The SOP, merely an executive instruction, cannot be equated with the rules and regulation formulated by the authorities under Article 212 of the Constitution. For this reason, the Constitution bench of this Honorable Supreme Court in the case Sukhdev Singh is not applicable. In the absence of statutory rule, state in exercise of its executive power can issue administrative instruction. Such executive actions, being gap-filling exercise, lack the force of law. On this score, the decision in the case of Dr. Amarjit Singh Ahluwalia is not relevant to the issue under consideration. Ramanna Dayaram Setti is a case emanating from notice inviting tender where certain relaxation was granted, which was challenged. The Honorable Supreme Court, though, has considered the principle of laid down in the case of William Vincent Vittorelli, but ultimately no relief was granted. Similarly, in the case of Darshjit Singh Griwal, the case of William Vincent Vittorelli, though, was considered, but no relief was ultimately granted. The case of Param Singh Supra is also not applicable in the present case, inasmuch as in the said case it has been held that unless there is a statutory scheme, non-statutory guidelines cannot be enforced. The case of Bhavna Tiyari is also misplaced in the facts and circumstances of the present case, as the said case relates to admission in medical college and allegation was large-scale blocking of seats. In the backdrop of such fact, the Honorable Supreme Court has made the observation regarding the counselling. In the present case, the petitioner has no grievance against counselling. The decision in the case of B.S. Minhas Supra is not applicable in the present case, inasmuch as the said case relates to employment in the body governed by statute. The decision in a case of Asha is also not applicable in the present case for the simple reason that the said decision pertains to adherence to a settled protocol in the process of selection of grant of admission. But in the present case, in the said SOP nowhere provides that the deployment is to be made according to the merit and preference exercised by the candidate at the time of counseling. Reply of Mr. Dhar. The SOP does not merely say counseling, but it clarifies that it should be counseling based on merit. It is preposterous to suggest that memo dated March 6, 2025 has got no relation with post-counseling deployment, and that fact of it starts that the effect of it starts and ends with counseling, inasmuch as a plain reading of this said memo would indicate that the counseling is also for the purpose of engagement. It is not a correct interpretation of the interpretation that the phrase "if offered to me" appearing in the self-declaration as required to be given by a candidate in terms of the aforementioned memo gives a discretion to the state to assign posting to any candidate in any place according to its choice. The correct interpretation of said phrase is that choice must commensurate with the rank. In other words, unless a candidate gets a rank befitting to his choice, he cannot have a right to get posting to the chosen establishment. Departure from it can only happen when the candidates fail to register himself within the time stipulated under the memo dated 4th March 2025. And in that event, department has the discretion to assign posting of a candidate in the remaining vacant seats after counseling. The facts of the case are not in dispute. The interpretation of the nature of the SOP and its binding effect are the issues under consideration, which are fundamentally pure questions of law, not dependent on the affidavit of the parties. Therefore, the doctrine of non-traverse has no manner of application in the present case. The petitioner has not alleged malafide of any authority or person. Therefore, the argument of the state on this score and the decision in the case of Ratnagiri are completely irrelevant. The decision of Lohia Properties relates to Order 8 Rule 5.1 of the Code of Civil Procedure, which clearly says fact. The said decision has no nexus with the issue under consideration, inasmuch as facts of the present matter, which ranking of the petitioner, vacancy, existence of SOP have not been disputed by the state. In the case of Chief Commercial Manager Supra, an existing statute and corresponding executive instruction were compared. The said decision has no application in the present matter inasmuch as no separate statute is under consideration here. In the case of R. Sai Bharati Supra, is a matter arising out of a criminal appeal where the code of conduct of the Chief Minister was under consideration. As such, is not relevant to the present matter. The case of S. L. Abbas Supra lays down the proposition of transfer in service jurisprudence, which is completely irrelevant to the issue under consideration. The division bench decision of Upanando Chatterjee is misplaced in the facts and circumstances of the case inasmuch as the said decision relates to removal of the prodhan and service of notice, which is purely procedural in nature, whereas the present case, the sanctity of the SOP and the applicability of Article 14 of the Constitution are the relevant issues. The argument of learned Advocate General that Ramanna Daram Sethi and in the case of Darshit Singh Griwal cannot be relied on by the petitioner as no relief was ultimately granted in the said two decision is not correct, inasmuch as the Honorable Supreme Court in the said cases, though has laid down rules inviting arbitrary action of in exercise of discretion, but has denied relief to the party only on the ground of delay, which is not a case here. Now the court Hard learned counsel for the parties peruse the materials on record. The state has sought to justify the posting of petitioner to Raiganj Medical College Hospital, Uttar Dinajpur, by ignoring the choice exercised by him during counseling on the ground that SOP is an administrative instruction having no force of law, list of a regulation. List of a regulation. As such, state is not bound to follow it. As the said procedure does not confer any right, therefore it is not enforceable. The state action is under challenge. To decide the sustainability of the said challenge, at first, it is necessary to introspect the scope of judicial review to such administrative action. No doubt, the scope is very limited. The law is well settled that it is not open to the court under judicial review to examine the validity of the decision, but the court can examine the correctness of the decision-making process. The Honorable Supreme Court in the case of Kesavananda Bharati versus State of Kerala reported in 1973 4 SCC 225 has held that in such case, the court reviews the constitutionality of an administrative action and also examines its fairness and reasonableness and justness. The Honorable Supreme Court in the case of Tata Cellular versus Union of India reported in 1994 6 Supreme Court cases 651 has considered the applicability of Wednesbury principle of judicial review, and at paragraph 80 the said report has quoted the said principle which speaks for itself. At this stage, the Supreme Court practice 1993 volume 1 849850 may be quoted. Wednesbury principle, what it is: a decision of public authority will be liable to be quashed or otherwise dealt with by an appropriate order in judicial review proceedings where the court concludes that the decision is such that no authority properly directing itself the relevant law and acting reasonably and have reached it. Quoted from Associated Provincial Picture House Limited versus Westbury Corporation as per Lord Green, MR. Paragraph 77 of the said decision is apposite to the context as such is quoted. Paragraph 77 of Tata Telstra. The duty of the court is to confine itself to the question of legality. Its concern should be whether the decision-making authority exceeds its power, committed an error, committed a breach of rules of natural justice, reached a decision which no reasonable tribunal would have reached for, or abuse of its power. Therefore, it is not for the court to determine whether a particular policy or particular decision taken in fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control of judicial review can be classified as under: legality. The means decision maker must understand correctly the law that regulates his decision making power and must give effect to it. Irrationality, namely Wednesbury unreasonableness. Procedural impropriety. The above are all the broad grounds, but it does not rule out addition of further grounds in course of time. As a matter of fact, in RV Secretary of State for the Home Department, ex-Brind, Lord Diplock refers specifically to one development, namely the possible recognition of the principle of proportionality. In all these cases, the test to be adopted is that the court should consider whether something has gone wrong of a nature and degree which requires the intervention. The Honorable Supreme Court, following the same principle in the case of Municipal Corporation, Municipal Council, Nimuk and Mahadev Real Estate and others, reported in 2019 10 Supreme Court cases 2738, has held that it is not permissible to the court to examine the validity of a decision, but the court can examine only the correctness of the decision-making process. Keeping such scope of judicial review in administrative action of the state in mind, let me now examine the issue under consideration. A plain reading of SOP clearly indicates that it prescribes a complete mechanism to get the service of SRs during the bond period smoothly and without any dispute. Therefore, it is not correct to say that the said document contemplates two distinct aspects, that is counseling and posting, or the choice exercised during the counseling would not directly reflect in the posting. They say it would suffice to quote paragraph 7A of the SOP to understand the purport of the said document. Then 7A quoted, counseling based on merit list prepared on the basis of collected stated particulars. The SOP, without any ambiguity, prescribes that posting would be preceded by counseling based on merit. Obviously, such counseling is aimed to achieve the principle of fairness and transparency as held by the Honorable Supreme Court in the case of Bhavna Tiwari Supra. In the present case, the state, following the mandate of the said SOP, has posted 869 out of 871 candidates in the hospitals opted by them at the time of counseling. But such mandate has not been followed in the posting of petitioner and another candidate. And in doing so, the state has compromised with the merit, inasmuch as Dr. Antara Danki, having merit rank 26, and Dr. Ripanna Chattopadhyay, having merit rank 34, have been posted in the hospital opted by them at the time of counseling, that is Arjikar Medical College, whereas the petitioner having merit rank 24 has been denied the posting in the said hospital, though opted at the time of counseling. The state has sought to interpret the phrase "if offered to me" appearing in the self-declaration of the petitioner to mean that it is the prerogative of the state to offer a seat unless such offer is made. The choice made in the counseling is not binding. This court is unable to accept such interpretation of the said phrase, as it would render the procedure prescribed under the said SOP in the matter of deployment of SRs nugatory. The logical interpretation of the said phrase should be that candidate must secure the merit position to get the offer according to his choice. The state sought to justify the said deviation from SOP also on the ground that the hospital where the petitioner has been posted has a higher requirement for SR in the relevant discipline than the hospital opted by the petitioner. The justification is too feeble, inasmuch as the deviation, if necessary, should start from the last ranked candidate. The Honorable Supreme Court in the case of Asa Supra has held that higher competition, greater is the duty on the part of the authorities concerned to act with utmost caution to ensure transparency and fairness. It is one of their primary obligation to see that a candidate of higher merit is not denied seat to the appropriate course and college as per his preference. The state has not disputed that it is bound to follow the principle laid down by the United States Supreme Court in the case of William Vincent Vittorelli, but has refused to apply the said principle in the present case, alleging that the SOP, being an administrative instruction issued only to regulate the service of SRs during bond period, lacks the force of law, even of a regulation, as such not enforceable. The Constitution Bench of the Honorable Supreme Court in the case of Sukhdev Singh Supra has held that even if the regulations have not got the force of law, the principle laid down in William Vincent Vittorelli should govern this situation. Extracts from the paragraph 122 is quoted below for ready reference. Then 122 quoted. The SOP is a tool designed to achieve the right guaranteed under Article 14 of the Constitution. Even if the SOP is an administrative instruction, the state is bound to follow the ethos of Article 14 of the Constitution to eliminate arbitrariness in the state action. In the case of Dr. Amjit Singh Supra and Ramanna Dayaram Sethi, the Honorable Supreme Court has laid down the principle that the nature of administrative instruction not having force of law, but the state government could not at its sweet will depart from it without rational justification. The said principle is equally applicable in the facts and circumstances of the present case. The Honorable Supreme Court in B.S. Minhas has laid down the administrative authority is bound to adhere to the procedural standards fixed by it to avoid arbitrariness, failing which the action taken by it would be invalid. The Honorable Supreme Court in the case of Darshit Singh Grewal has held that it is axiomatic that having enunciated a policy of general application and having communicated it to all concerned, the administration is bound by it. Of course, it can, of course, change the policy, but until that is done, is bound to adhere to it. The paragraph 14 of the said judgment is quoted below for ready reference. Paragraph 14 quoted. The decisions cited on behalf of the state are not applicable in the present case for the following reasons. An order of transfer is an incident of government service in the backdrop of the said settled position. The Honorable Supreme Court in the case of S.L. Abbas and in the case of Govardhan Lal has held that a transfer made even in transgression of administrative guideline cannot be interfered with, as they do not confer any legally enforceable right unless shown to be vitiated by malafide or made violation of a statutory provision. Those decisions are distinguishable in facts. The case of R. Sai Bharti, though is a factually distinguishable in as much as the matter relates to code of conduct issued by the state government under Article 162 of the Constitution for exercise of executive authority by minister. Nonetheless, the Honorable Supreme Court in the said decision has held that the good ethical behavior on the part of those who are in the power is the hallmark of good administration, and people in public life must perform duties in the spirit of public service rather than assuming power to indulge callous cupidity regardless of self-imposed discipline. In the case of G. Ratnam and others, while dealing with an issue whether a disciplinary proceeding initiated against a railway employee would be vitiated for not following the certain guidelines contained in the vigilance manual, the Honorable Supreme Court has held that such instructions do not have the force of statutory rules, as such do not confer any right on any member of the public to ask for a writ against the government by a petition under Article 226 of the Constitution. In contrast, the state by the SOP has not issued a mere administrative instruction to its servants. It lays down a complete procedure for engagement of doctors to get their service for the bond period. The state is following the said procedure for deploying a set of candidates, but is denying to follow it for 2 candidates only. The arbitrariness of the state in the said action is on the face of it, and as such, such action offends Article 14 of the Constitution. In the case of Upananda Chatterjee, is no pointer to the issue under consideration. The decision of the Honorable Supreme Court in the case of Lohia Properties is misplaced in the facts and circumstances of the present case, inasmuch as issue falls for consideration relates to pure question of law to be decided on the basis of undisputed facts. Therefore, doctrine of non-favors has no manner of application here. The petitioner has not made out a case of malafide. Therefore, the decision of the Supreme Court in the case of Ratnagiri and Power Limited has also no manner of application in the present case. Conclusion: summing up the discussion made above, this court holds the decision of the state to deploy petitioner at Raiganj Medical College and Hospital Uttar Dinajpur clearly violates the Wednesbury principle. Thereby, the state has committed a serious wrong which demands intervention. Accordingly, the issue is answered in affirmative. As a result, the impugned notification dated May 27, 25 and the list annexed thereto, so far those documents relate to the deployment of the petitioner at Raiganj Medical College and Hospital Uttar Dinajpur are set aside. The department is directed to deploy and or engage the petitioner in the second vacancy of the SR in the discipline of anesthesiology at RG Kar Medical College with immediate effect.
Deeply obliged.
My lord, I'm praying for a stay of operation of this order, my lord. up to 7th of October, my lord, considering the fact that 3rd of October is the first date of the vacation bench, my lord. We will kindly record this.
Mr. Nag, learned advocate, the state, praise stay of after delivery of judgment. Mr. Nag, learned advocate for the state, praise stay of the operation of this order, judgment and order, at least till the 7th of
October, my lord.
October,
Considering that it is the ensuing Puja
October,
vacation and the first date is 3rd of
7th of October 2025. To have the opportunity to prefer an appeal before the first available vacation bench. Prayer is considered and refused.
Obliged.
Only one sentence. Lordship took the pain of, I believe, every submissions, every point of both of us. Deeply obliged.
No, actually, what happened? Why I'm late today?
I understand.
In the morning when I'm going, that I think that there's something
Each of the point deeply
It's a very tedious job.
I understand.
Very tedious.
I
job.
understand.
At least before vacation.
I understand.
Before vacation makes it more tricky.
Yes, Mr. Nag, you require for another thing.
Mr. Jawar is there. Document admission 26th admission হয়ে গেল তারপর আমার give me a soft copy. I will immediately send it to the department. And
should I take it before vacation? I can effort to stand over after vacation.
Cancellation হয়ে গেছে তো সিটটা ক্যান্সেল করেছে থার্ড রাউন্ডে ফিল আপ করে
what suggested by my learned senior friend is if there is no order, then it is automatically, my lord, by mechanism it will be shown vacant in the next round, which will be during vacation. So perhaps, my lord, I should not say that there is no urgency. Then it will be unfair.
But why I'm telling this? I've heard this. I have not. We have no occasion to see it.
Understood.
I've heard the English judges used to ask Mr. Apurvadhan Mukherjee,
Well,
because in the list almost all matters under Order 41 are of him.
well,
Which are the matters according to you? Mr. Sen may say that, we can justify that. Or we have heard it also.
well,
That which are the matters according to you we can admit. Then he took the list, said that these are the matters to be admitted and these are the matters, please hear me. দিয়ে দাও দেখি যদি
soft copy আমাকে WhatsApp হ্যাঁ
I am for the petitioner, my lord.
you are for the
My lord, I am for the petitioner, my lord, the review applicant, my lord, in this matter, my lord.
I am for the decree holders, my lord.
you have
My-
mentioned.
My lord will fix a date any day after vacation, my lord, in this matter. My lord, I am led by Mr. Kolyan Bandopadhyay and Shishanu Bandopadhyay, my lord, in this matter. Any
Maybe.
date.
Maybe as you have engaged Mr. Bandopadhyay, ask him to argue today.
My lord, he is not, my lord, it is not possible today, my lord. My lord,
You are quoting his name. Where is he?
my lord, Mr. Shishanu Bandopadhyay, they are briefed in this matter. I couldn't hold conference with him. I am sick, my lord. Today I am appearing from my house, my lord. I have a heavy...
Bandopadhyay, come once. When you are quoting the name, please ask Mr. Bandopadhyay immediately to come. This is obstructing your execution.
My lord, right now, my lord, the execution proceedings are there because there are certain applications which need to be disposed of. What has happened, my lord, the review is mentioned from time to time. They had filed the review before this honorable court, my lord, while the SLP was pending before the Supreme Court. They kept the matter in defect for nearly a year, my lord.
Review.
Please, my lord. No, the SLP in defect over a year, stating that, well, we have filed a review and therefore we are trying to get the matter heard. And then after, my lord, they withdrew the SLP on the grounds they want to hear the review. I have the application with me, my lord, and they're saying that the matter is being adjudicated. It's pending adjudication before the Honorable High Court. And it was on that basis that the Honorable Supreme Court was pleased to allow their SLPs which were unregistered. In the
Allow
draft state,
SLP, allow.
allow them to withdraw the SLPs, although unregistered, and for a period of 8 months, my lord. And I have the judgments with me, where in the order the Honorable Supreme Court has recorded that the submission is made that the review is filed before the before the High Court and is pending adjudication. That was the application they moved, and this was recorded in the orders.
Pending. That is why they have withdrawn the.
Yes, we have withdrawn our SLP, my lord.
Is pending, but the submissions made were, we are trying to get the matter heard, which is why, my lord, they were given so much of time to either get the matter heard or
What is your obstruction in the execution?
My lord, they also mention the matter. What happens is, my lord, they don't move applications. They mention the matter. We are now about to get the review petition heard. Kindly grant.
Is there any application in the court below?
No, my lord.
My lord, there is a clear order of your lordship. This will not stop the execution. They are proceeding with the execution before the Alipur court, my lord. They are proceeding with the execution in the Alipur court.
The review.
So
there is no order.
Review, your lordship, fix a date after vacation. Let it be heard, my lord. We don't have any objection, my lord.
They may get next year, they may get a new judge to get this matter reviewed. Maybe a good strategy.
Please, my lord.
My lord, your lordship, hear it. We bow down before your lordship. After vacation, your lordship fixes the date. We bow down before your lordship. We want to hear this matter by your lordship itself, my lord. My lord, we don't have any problem.
I am not for a moment trying to pressurize. No, not at all, my lord. All I am praying for, in the meantime, the pendency of the review
petition really pending.
should not have
eviction suit of 1980.
Please, my lord. And both are, my lord, both the decree holders are senior citizens. The Protul Shah, the first decree holder, suffered a stroke. He's a stroke survivor. 45
How can we
years.
expect if more than 40 years the eviction suit, 44 is
Yes, my lord.
The tenant successfully kept it pending?
And all I'm praying, my lord, not at all any kind of pressure, but in the meantime, the pendency of this matter should not hamper.
That I have already, what he is saying, I have already clarified.
No,
already in the order, my lord, your lordship's order already, there will not stop execution, my lord.
Past any
Another civil revisional application. In another civil revisional application, my lord,
that is
that order has
revision which was not
in this matter,
my lord, now. That is in respect of the promoters, private promoters.
Yes,
not review.
Then, yes, Mr. Banerjee, take instruction of your senior when he will be available. I will not adjourn for any advocate.
No, my lord, after vacation, my lord, your lordship fix any day.
Fix a date, I will not adjourn for anyone.
Yes, my lord. After vacation, after 15 November, any day.
You consult your senior, get a date, give me to me.
My lord, my lord.
Not be embarrassed. You will not embarrassing me.
My lord.
Adjournment for any senior.
My lord, my lord.
Come tomorrow, give me a date.
My lord.
Grateful.
You argue, let me go through,
No,
you argue on
of
the
course,
next date.
this gives your lordship not the.
Yes, where is the other set of advocate who? Please ask Mr. Mojumdar to hand it over. I have heard Mr. Kaur for substance.
I had a talk with Mr. Mojumdar today. He said that his notes are also ready. I'm sure.
Let me go through it. Mr. For soft copy. Yeah, ask him. He can.
Noted soft copy.
You also, please give me a soft copy. Pen drive, give it. I will take and I will return the pen drive. And ask Mr. Mojumdar to give it.
But can we transfer it in your lordship's?
Okay, দাও না এটা কি করে যেন এয়ার ড্রপ করে দেবে খুলে দিয়ে দাও
আচ্ছা একটা জিনিস দেখুন
খোলা আছে দিদি সেটা খুলে দাও
জাজমেন্ট গুলো দিচ্ছি আর আপনার যেটা হচ্ছে সাবমিশনের নোট পয়েন্ট ওয়াইজ সেটাও কি দেবো এটাও কি দেবো না ওয়ার্ক স্পেস দেওয়ার দরকার নেই রিটেন নোটস তো
সেটা দেখে আমি যেটা কবে করবো বলুন তো
ঠিক আছে
আমি আসছি তো 10-এ 14 কিছু আছে দেখো তো
হ্যাঁ তাই
ওর বেশিক্ষণ লাগবে না 14 কটার সময় আছে ওটা 14th point number 12:30 or 12 14 12 দেখি একটু ফাইলটা দেখি একটু ফাইলটা একটু
ঠিক আছে তবে শুধু নোটটাই দিচ্ছি
ওই তো মিস্টার মজুমদার
নোটটা চাইছি নোটটা
argue make it complete, give it tomorrow.
There are three broad guidelines.
Make it complete, give it tomorrow.
Okay.
I'm not recording, I'm not treating his notes on argument. This is nothing but to get the court to get idea what line you will be arguing. Give it tomorrow. Give it to ask your junior to give it tomorrow.
I have prepared it, I shall correct it.
না এটা ওনারটা ও তোরটা দিয়ে দিয়েছে
না একটু কারেকশন করব
এটা নিশ্চয়ই আমাদের ও আচ্ছা এটা ওদেরটা তোমাকে না আমাদেরও হার্ড কপি দিয়ে আমি সফট কপিও দিচ্ছি হার্ড কপি দিয়ে দিয়েছি হার্ড কপি দিয়েছিস
দেখি
জজ সাহেবকে দিয়েছেন হ্যাঁ হ্যাঁ
এটা কাদের
ঠিক আছে না বিশ্বরূপ ভট্টাচার্য
You are the added parties here. Refer to your respondent numbers. Oh, আচ্ছা ওটা নামটা লিখে রাখো এটা হচ্ছে বিশ্বরূপের তাই তো so that I can identify at least.
With all notes or our notes only?
No, yours only. Yours
will.
Only.
I will.
Otherwise, I will summon you to North Bengal. One thing is only one thing for you.
My submission will be the stronghold of Mr. Bhattacharya's argument has been that it is violation of Articles 14 and 16. Now, to that, my first submission is Article 14 and 16 will have no manner of application in this process, number one. Number two, SSC Act 1997 with the all following rules and regulations won't apply in the facts of this case. Apropos, not the subsequent amendments to the 1997 Act.
These are the two broad areas you want to. Please develop it, give it to me so that I can understand.
And not in the anvil of 1963 Act, whether the action can be said to be justified.
1963
West Bengal Board of Secondary Education Act 1963, read with the management rules.
Very well.
পাঠিয়েছি accept করুন. In fact, Article 14 and 16 is partly argued by me also. Because
You have not concluded.
I have not
You have not concluded. Possibly your argument to the area that when there was a prevailing situation was that.
I'm not, my argument would be that when the authority can't hold examination because of extraordinary situation prevailing, there is no question of granting equal opportunity.
Constitution was not suspended.
Constitution was not suspended. But I'll make
Very well, very well.
My submission is this: even if the situation would not have warranted this action to be taken, then also Articles 14 and 16 would have no manner of application in this case. It is not a case of public employment.
It is not a case of public employment. এটাকে ইয়ে করে রাখো. Place the mandatory list on data কবে দিন? November 14.
Public function. সেই জন্য এটা jurisdiction আছে. This is not Article 12.
Hearing would be taken up upon 12. But I will not effort to give you much time. Make it precise. Make it precise.
These are the 3 points. I'll only show you the development of the rules and the approval of the 1997 Act. Half an hour for me.
Lord, I had appeared before your Lordship when your Lordship was sitting in court number 19, but client had not been in touch for some time. And just appeared
Your
suddenly.
name has been copied, senior Mr. Bandyopadhyay's name.
I heard from my junior, my lord, but the matter came up so suddenly, my lord, I could not get in touch.
I don't know. When
I had appeared in the matter in court room number 19.
That was a revisional application.
Yes.
It is not that.
No. At that time, review also
Are you
was.
in the review matter?
Yes, review was briefed to me, but my lord, there has not been any contact, my lord, because maybe the matter was not in the list.
Adjournment is taken or quoting the name.
I told
of
my lord, the learned advocate that if you are taking time on our ground, at least let us know. There's a minimum you can do. Because
ask Mr. Senior Mr. Bandyopadhyay that I'll be fixing a date tomorrow. According, if he is the matter, then according to his convenience, otherwise no adjournment will be granted.
Right.
An 80 suit of eviction on the ground taking name of some senior counsel adjournment, I will not allow.
Right.
Tomorrow I will be taking the.
I'll come back at 2 o'clock, my lord, to apprise your lordship.
If you can, but I asked him that it is not for you. It is for senior Mr. Bandyopadhyay's time.
We ought to have been informed, my lord. At least Mr. Bandyopadhyay should have been informed that we are taking adjournment on your ground. Well, I am too young to be given that.
Date to be fixed according to his availability. No. Please apprise this.
My lord. Great.